Good evening and welcome. My name is Yari Krivoy. I'm a senior fellow here at the British Institute of International Comparative Law, and I'm also running the Investment Treaty Forum. And it's my pleasure to introduce today the last event of this season on mining disputes. We're going to discuss ISDS, ESG, and valuation challenges related to these disputes. It has been a very busy year for the Investment Treaty Forum. We had 7 events and saw a report about all those events. And we are interested to hear your feedback about this event and also about other events, and also look forward to discussing possible ideas about projects, about publications, about events for the coming year. We plan to release at least 2 research papers next year, one dealing with sanctions and international dispute resolution, and the other one will be about technology disputes and international arbitration. So hopefully there will be 2 events on those topics, in addition to our traditional 2 conferences, one in spring and one in autumn. And in the meantime, let me advertise our course, our online course, International Investment Law and Dispute Resolution, which you can take at any time, and it's particularly popular with junior lawyers, those who work for law firms or those who work for governments, because they allow to introduce people to international investment law in an easy and not a very boring way, because I lecture on those topics myself, and then I interview people who are experts in those areas. So International Investment Law and Dispute Resolution course, you can Google it and you will be able to find it. If you want a group discount, please either contact me or our events team. And we have a number of people in the room, but we have even more people joining us online. And I think the majority of people joining us online are representatives of governments from various parts of the world, from Latin America to Australia, various European countries. So it's very good to have so many people and governments and regions represented in the room. If you work for a government and your government hasn't yet joined the Investment Treaty Forum as a consultative member, please let me know. We invite governments to join free of charge as consultative members, so that you can attend our events, so that we can invite you to speak at our events. And our other members appreciate having government members in the room, because it's always good to have their insights and their thoughts on the topics which we discuss. Thanks again to Curtis, to Luciana for putting this together. It's very good to continue this tradition of Curtis events hosted at BIICL. I hope you will enjoy it. And now let me invite Arthat Kulenkar, who is a lawyer and associate working at Curtis, originally from India, but he did a master's degree at Oxford and also at BIICL in Geneva, and now he works with Curtis team on various arbitration disputes. So over to you, Arthat, and you can turn on any microphone, and then we'll have some time for questions at the end. We will record the presentations and we'll make them available for members, but we'll not make available the Q&A session after all presentations will be over. Thank you very much, and enjoy the event.
Thank you, Professor.
If you could use your microphone so that online people can hear us. When the light is red, then it means it's working.
Thank you, Professor. It's a privilege to introduce this panel on mining, which is so important and so topical in the current climate. So mining sits as the epicenter of some of the most consequential investor-state disputes that are currently happening. Some of the largest investor-state claims, and I'm sure we'll cover some of those, ever brought, have stemmed from mining projects, cases that have tested the boundaries of investment arbitration, state sovereignty, and expectations around sustainability. Beneath the surface, quite literally, lie not only valuable minerals, but also a complex web of competing interests, rights, and responsibilities. At the heart of these disputes are key actors whose interests converge and sometimes collide. First, the state, obviously, which has sovereignty over its natural resources and is charged with managing natural resources in the public interest. The state bears the duty to manage mineral resources for the collective good, balancing fiscal objectives with social welfare, environmental protection, and adherence to international obligations. Its regulatory choices often become the focal point of scrutiny in investment arbitration. To share the state's perspective, I'm delighted to introduce our first panelist, Ms. Lourdes Martinez de Victoria Gomez. She's a key part of the legal team at the International Arbitration Department of the State Attorney's Office of the Kingdom of Spain. She has represented Spain in more than 25 investor-state disputes and brings with her deep knowledge and understanding of state concerns in mining-related disputes, and the uncertainties that states face in navigating such ISDS claims. The second voice in this story is that of local communities and indigenous communities. Their interests intersect with both the legal and ethical dimensions of these disputes. Indigenous communities have connections to land and natural resources which extend beyond economic value to encompass basic rights like cultural identity and traditional stewardship. Local communities may also have an interest in protecting their rights to a clean environment or other rights afforded under domestic law. The indigenous and local community participation challenges conventional notions of who the legitimate stakeholders in investment disputes truly are. To bring this perspective to the panel, please welcome Ms. Monica Ferrer-Tinta. Ms. Ferrer-Tinta is a barrister at 20 Essex and a widely recognized practitioner in the fields of environment, energy, human rights, and public international law. In addition to her many accolades, she holds the elusive Diploma in International Law from the Hague Academy of International Law. She represents indigenous and local community interests in several disputes, including in mining-related cases. One noteworthy example, and we will hear more from it, about it, is her representation of the Wayuu people, a community located in northern Colombia and Venezuela, to halt work at a pit coal mine owned by BHP, Anglo American, and Glencore. The third actor is the investor, who acts as the initiator of capital-intensive mining projects. Investors bring, or are at least expected to bring, technology, expertise, and financing to a mining project. With a regulation-intensive field such as mining, investors are required to navigate complex host state environments marked by dynamic political and regulatory landscapes. Their expectations of treatment and protection under treaties frequently collide with evolving domestic priorities related to sustainability and equity. Representing this dimension, I'm pleased to introduce Mr. Richard Bole. Mr. Bole is a mining sector consultant and was the chief advisor, general manager of strategic projects at Rio Tinto Copper, one of the biggest companies in mining, for several years, and he oversaw projects in the copper and diamonds department in Mongolia. He brings with him several years of insider experience into the mining industry and an informed perspective on how mining projects are envisioned at their infancy, what is required to bring a mining project and what to execute one, and the risks that such projects carry. He will also touch upon the mining industry's general compliance with ESG norms. Finally, we turn to the council, those who operate at the center of investor-state disputes. Investor-state arbitration lawyers, many who have joined this panel, are tasked with contesting and defending claims that can reach staggering sums, raising profound questions of fairness and proportionality of damages in international law. To illuminate this perspective, please join me in welcoming Curtis partner, Mr. Juan Carlos Boe. Juan Carlos is a partner in the International Corporate and Arbitration Practice at Curtis. He holds a DPhil from Oxford in politics. He has spent a decade at the helm of the international trading arm of Mexico state oil company Pemex, and has also served as a special advisor to the Venezuelan Minister of Energy and Petroleum. Together, these stakeholders, the state, the community, the investor, and council, provide a framework for understanding the international law, politics, economics, and ethics of modern mining disputes. Today's panel will explore how valuation ESG principles and evolving dispute frameworks are reshaping notions of accountability in the mining sector. With that, I turn it over to Ms. Lourdes Martinez Victoria Gomez.
Thank you very much, Arthur. Maybe I will take this micro is all thank you. Thank you very much. Well, good evening. First of all, I would like to thank you, BIICL and Curtis, for inviting me to participate in this panel. It is an honor for me to be here today. Before I begin, I wish to say that all the views that I express here today are my personal opinions and do not represent the official position of the Kingdom of Spain. And having said that, as many of you know, over the last decade, Spain has faced more than 50 arbitration proceedings, mainly related to the reform in the renewable energy sector. Investor claims over 10.6 billion euros, but tribunals awarded 1.8 billion euros up to date, with 4 awards still pending. The case of Spain is very particular, since not only some tribunals have declared their lack of jurisdiction to hear intra-EU disputes, but also because they have reached very different conclusions regarding the interpretation of the fair and equitable treatment standard under the ECT. In this sense, we have, on the one hand, some tribunals that found that the reforms constituted fundamental changes that violated legitimate expectations of investors, and therefore declared that Spain has breached the fair and equitable treatment standard under the ECT. On the other hand, we have other tribunals such as Tehran, Isolox, Stadtwerke or FRAVE tribunals that found no breach and declared that Spain has not made specific commitments to investors to freeze their regulatory regime. In this sense, they basically confirmed that the only legitimate expectation that investors could have, it was to obtain a reasonable rate of return in accordance with Article 30.4 of Act 54/1997 on the electricity sector. So you can imagine this variability of tribunal approaches to both jurisdiction and legitimate expectations raises considerable concerns since a legal certainty perspective. And moving from renewable energy to mining arbitration, which is the topic of this panel, I personally believe that due diligence is crucial in mining arbitration. Mining investors must conduct rigorous due diligence regarding legal, social, and environmental risk. Mining, as you know, is a highly regulated sector which requires a diligent analysis of the applicable legal framework. For instance, tribunals often assess whether investment has been made in accordance with the host state laws, including environmental permits or anti-corruption rules. If investors fail this basic test, tribunals may decline jurisdiction or maybe declare the claims inadmissible. Now, some cases illustrate this principle. I briefly want to refer to some cases. For example, in Colt Mining versus Kenya, the tribunal declared that the mining license was not a valid protected investment because it has been issued in violation of Kenyan environmental law, including the failure of the investor to secure an environmental impact assessment. And therefore, the tribunal declared that it lacked jurisdiction to hear the dispute. Another case is BSG Resources versus Guinea. The tribunal in this case underscored that investment tainted by corruption cannot gain treaty protection and therefore declared the claims inadmissible. For instance, in tertiary mining versus Indonesia, the tribunal held that willful blindness to local partners' fraud barred treaty protection and therefore also declared the claims inadmissible. And recently, I want to refer to another case, Red Eagle Limited versus Colombia. It is a case where the tribunal determined that the claimant did not have an acquired right to mine in the Palermo area since the concession was conditional on obtaining environmental licenses and additional approvals, subject to state discretion. The contested measures, which were the prohibition of mining in the Palermo area, were considered a legitimate exercise of the state's regulatory power for environmental protection. The tribunal emphasized the importance of environmental protection and the sovereign power on the state to regulate the use of natural resources, considering mining a highly regulated sector. Another example we can refer very briefly is PAC-RIM Cayman versus El Salvador, which shows the tribunal's deference to state interpretation of their own laws where investors fail environmental or permitting requirements. And given mining significant social and footprint, I personally believe that a tribunal should adopt a restrictive approach to legitimate expectations, taking into account that mining is a highly regulated sector. Investors must anticipate regulatory evolution and respect environmental, social, and governance standards. In this sense, I believe that a tribunal should integrate domestic and international obligation when considering the applicable legal framework and when analyzing the different substantive treaty provisions. In this sense, systemic integration under Article 31(3)(c) of the Vienna Convention on the Law of Treaties is fundamental for arbitral tribunal when interpreting treaties, especially those treaties, so-called old generation treaties that maybe do not contain ESG considerations. Having said that, I want to refer also to the ICJ advisory opinion on climate change rendered on the 23rd July 2025. I think that this advisory opinion, even if it is not binding, will have an enormous impact both in arbitration proceedings and also in treaty practice. In this advisory opinion, the ICJ reaffirmed that states have a customary duty to prevent harm to the environment and to cooperate for its protection. In a similar vein, it is worth mentioning the recent advisory opinion dated 3rd July 2025 of the Inter-American Court of Human Rights, or the advisory opinion of the International Tribunal for the Law of the Sea dated 21st May 2024. A couple of weeks ago, the European Court of Human Rights also rendered a judgment dated 28 October 2025 in the case Greenpeace Nordic and others versus Norway. Even if the court did not find a violation of human rights, it referred to the importance of the environmental impact assessment before authorizing oil and gas projects. And finally, regarding treaty practice, I want to include very soon treaty practice. It is important to make reference to the issue that Spain, as well as other countries, have recently withdrawn from the Energy Charter Treaty and referring, among other reasons, for the incompatibility of this treaty to climate goals under the Paris Agreement. Spain's withdrawal in 2024, effective in 2025, is a part of a broader trend which comprised the United Kingdom and the European Union. Meanwhile, a new generation treaties, such as Colombia-Spain Bilateral Investment Treaty, which is not yet in force, also includes ESG considerations, and for example, in Article 14, referred to the state's right to regulate for legitimate public welfare objectives. Also, it contains other provisions which prohibit reducing protection in environmental, labor, and human rights legislation. In a similar vein, we can make reference to the model clauses that has been approved by the European Union. Those clauses which will serve to the negotiation of bilateral investment treaties also contains ESG considerations. And at this point, I find interesting also to refer to the July 13th report by the Office of the United Nations High Commissioner for Human Rights, which recommends states consider removing ISDS provision from future treaties, taking specific actions to safeguard their regulatory space and human rights. And finally, as many of you know, the European Union is actively promoting and its member states the creation of a multilateral investment court. This court aims to replace the traditional ISDS arbitration system with a permanent rule of law based court that includes transparent procedures and an appellate mechanism. To conclude, all actors, this is my point of view, directly or indirectly involved in mining arbitration, states, investors, lawyers, and arbitrators have an enormous responsibility to protect the environment and human rights. Thank you. Thank you very much.
Thank you, Lourdes. That was very, very interesting. The cases you mentioned, Cortec and BSG, a recent dispute in Cumbria comes to mind in the UK, where similarly a planning permission has been cancelled by the English High Court, and now the investor seems to be claiming in ISDS. So there are several disputes like that which keep happening. Thank you very much. With that, please may I invite Ms. Kayatinta to present. She would be presenting with slides. So let me just see if I can. I think.
Yeah. Yes, so thank you very much for the floor. I wanted to bring up this case study to use it as a way of looking at what type of issues when it comes to human rights may arise in this context. Perhaps you can go to the next. So this is the case of a dispute, an arbitration dispute concerning Colombia and Glencore. But let's take first a step back before this dispute was filed and look at a little bit about what was the history of this particular investment. So on the picture, you can see the Cerrejón mine, which is located in Colombia. It is the biggest coal mine in Latin America and one of the biggest in the world. And this is open pit coal mine. So I don't know how many of you are familiar with what it entails to do coal mine, but it does require a huge amount of water. And this is in a desert, by the way. And what is interesting is that the Cerrejón mine has been already operating in Colombia for decades. So we're talking about over 30 years of being there. But what has been happening is that it has grown little by little. Basically, we are having a mine that operates 7 days per week, 24 hours per day. so it doesn't stop day and night. And there is a specific train that takes the coal all the way to the port, eventually to its destination. What does that mean in this context? There are communities that are Afro descendants and also the Wayuu indigenous peoples. And there has been an ongoing crisis surrounding how the mine has been growing, to a point where I acted as counsel in a case that arose around the time that we were going through COVID. And over there, the issue was that to mine something like this, you need huge amount of explosives. And that means there is a lot of dust. Water is being really used to control the dust. Now, these particles in the air are hugely detrimental to health. And there has been a number of studies about it, including studies in Colombia. And there were a range of court decisions in Colombia, plus also measures decided by the Inter-American Commission on Human Rights surrounding the situation of Wayuu communities concerning health issues. In particular, there was one in 2017, the Constitutional Court said, you have to stop, you have to take certain measures, that this was to ordering certain measures to the companies owning Cerrejón mine. So when I was instructed, the companies that own the mine were some of the most powerful companies in the world concerning energy-related issues, and that was Glencore, Anglo American, and BHP Billington. Now, I was successful in arguing the case for my clients, and you could say, to the extent that the Special Rapporteur on Environment and Human Rights issued a very unprecedented decision after engaging with the parties, which was to ask the mine to stop, at least during the COVID crisis, from working, because at the time we knew how people that were already exposed and vulnerable because of pollution in the air could be even more likely to be vulnerable if you caught COVID. So that was the idea at the time. And for those who don't know what particles in the air do to human beings, it's quite, actually I learned that it was quite extreme, particularly the kind of particles that are invisible to the eye. And WHO limits were not really complied with. And the kind of cases were from respiratory issues to DNA changes in people. And they had already tested these at universities in Colombia. So this was quite an acute situation. So where do we go next from there? This win, in a way, was had a very direct development, which was that a lot of shareholders, for example, of BHP Billington, were not happy with probably with this type of facts, and they wanted to move away from coal mining. And so BHP Billington sold the shares, and so did Anglo American as well around the time, which in a way was good news for the communities. You know, they are moving away from coal mining in a context where Paris Agreement was already a reality. So the whole track was, you know, we are moving away from this type of energy-related projects. But Glencore stayed as the sole owner of the mine. And the next thing that happened was an investment arbitration where the key issue request, and the key issue here, and tidying up a little bit with what you talk about in the case of Cambria here. So the whole investment arbitration case arises from the decision of Colombian courts. So, and it was very specific. It was not about the whole spectrum of issues. It was really about an expansion. Yes, in the context of the Paris Agreement, post-Paris Agreement, Glencore intended to expand the mine. And for doing that, can we go to the next? for doing that, basically, they needed to divert rivers, and in particular one river, which was called the Bruno stream. Now, this is quite an important issue, water, because in 2019, Cerrejón extracted 10.733 million liters of surface water, including water from wetlands, rivers, lakes, oceans, so everywhere. The communities around receive water in bottles. They cannot access any more water from the rivers because they are already polluted. And that's what they have handouts in the desert. But the Bruno stream was targeted because the mine wanted to mine coal from the riverbed. And I have to be honest, when I look at the different reports, to me it was quite shocking that the need for profit was such that you would go and even play God in a way and just change the course of a river just to get more coal from the riverbeds. And I kind of thought, so the courts replied to a challenge filed by communities. So it's very interesting who triggered, in a way, the review of the legality of this. And the Constitutional Court of Colombia was not satisfied that what the company attempted to do was in accordance to the law. And it requested further impact assessments, etc. But there have been already Colombian ombudsman reports as to the situation and how also these changes, hydrological changes, were impacting the region further to a point where climate change was even more radical and to a point where you couldn't support life anymore, the topography of what it was going on. So the key question here is, I say there are two things really around this case, and we are going to see quickly what are the positions of the parties. But number one is, how far can you go to challenge judicial decisions from the highest court in a country, and to say that your legitimate expectation, for example, would have been that a court cannot possibly do so? How do you define arbitrariness in that context? And I'd be very curious, to see how an ISDS case concerning a court in England looks at that vis-a-vis a court in Colombia. And the second big question, I think, behind this case is, in a context where we are post-Paris agreements and where certain investments necessarily are not any longer regarded as having a lifespan that in the past we could have considered such projects to have. I mean, there is a major change at present. So to what extent you can say that the value of your investment, even if you were to be right, let's say, is the kind of value companies are still asserting around, for example, a mine that has already been out there for almost 40 years. I mean, how far are you going to extend that value? So I think that raises a very critical issue, and we were just discussing before we started the panel. I was commenting on an article I wrote, which is coming up in a book on non-traditional sources of international law. My task was to look at arbitral awards and what value, if any, in terms of precedent, in the way we know the meaning of precedent in international law may have. Because even in international law, in cases that come from courts, international courts like the ICJ and others, there are certain critical moments where the law moves. And this has happened, for example, in maritime type of law, when the law settled and changed and move away from what maybe previous decisions from the same court, we're talking about the ICJ, may have been about. And I think that those critical moments are around those shifts. If we were to compare that to investment arbitration, probably climate law and how fast it's developing, providing clarity in many aspects that before were not clear, add to that. And maybe that is something that has to be considered when looking back at investment arbitration itself and how you interpret law. Why am I saying that? Because I think that it is certainly the case that, for example, if we think about this case, Colombia, the Inter-American Court of Human Rights has gone further than the International Court of Justice, saying we are talking about use coherence principles. So this is a very strong way to, when it comes to climate law and climate protection. So if you think about a case like this one, where the whole thing is about really climate, it is really interesting to see in what way these new developments are going to play a role at all in decision making. And very fast, let me just go to what they are arguing. Yeah, so this is the position of the claimant. Let me get rid of this so I can see. So this is the position of the claimant, and this is interesting because, so the claimant, Glencore, is arguing that this is really unfair, inequitable, and unreasonable measures. The measures are the decision of the Constitutional Court. And it says that it prevents Cerrejón from continuing the fully authorized expansion of this bit, which is the one that required the moving of the Bruno Creek, as they call it in English here. So, okay, let's go to the next. And here, it is interesting as well that is considered arbitrary, unreasonable, inconsistent, and disproportional measures that it frustrates claimants' legitimate expectations. So you see, this is a key argument in breach of the treaty. The treaty here being the Swiss-Colombian BIT. And notably talks about the 2017 Constitutional Court decision, which suspended that diversion of the Bruno stream. And until now, it's suspended. And it does mention the communities that filed the lawsuit, notwithstanding that the competent authorities had already concluded, etc., etc. So one of the key issues about this is the impact assessment that was not considered to be. In fact, there is no impact assessment in the whole development in La Guajira, in Colombia. There hasn't been ever an impact assessment. And the reason why Cerrejón Mine justifies this is because when the project started, that's almost 40 decades ago, the law didn't require certain impact assessments. So we are already almost half a century later, and they still consider they are not bound by Colombian environmental law or any law really. So that's a very interesting point. I don't know whether it's going to be at all discussed in this context. Can we go to the next? So this is now the Colombian rebuttal. And so actually these are all public documents. So you can, if you're curious, you can look into both. Glencore is represented by Freshfields, and Colombia is represented by Aaron Porter. So documents are all out there on the internet. So what Colombia actually said is that the Cerrejón Mine's activities have been conducted since 1976, have had a devastating impact in the region, and in particular on the Wayuu people. And such activities have led to the extermination of tropical ecosystems, the contamination and disappearance of water sources, air pollution, and the displacement of local communities. So the claimants' mining activities require vast amounts of water, resulting in significant water extraction in a region that has one of the greatest water deficits in Colombia. Can we go? And it talks about circumvention of obligations. And further, then focuses on the diversion of the Brunner stream to exploit the coal beneath the riverbed face. That he faced opposition, and this opposition was quite strong from indigenous communities. Perhaps also to highlight the fact that the whole claim really is challenging judicial decisions, primarily by Colombia's Constitutional Court. There has been over 17 decisions by Constitutional Court against Cerrejón, and the company never complied with any of them. And when I took up the case to the special rapporteur, etc., was really because of the main problem that whether a country like Colombia could have the ability to enforce its own constitutional court cases. So I think I'll go to the next. I think I will stop there, but I wanted just to kind of leave you with these two positions to reflect and see how far can we go when we talk about these kind of projects to argue that a specific investment is being affected vis-a-vis fundamental rights of communities just to basic survival. So I think, in particular in the context of climate law now, I think we are on protection of nature. It is a challenge, and it brings a different dimension to the whole investment arbitration aspect. Thank you.
Thank you so much. On a quick reflection on what you said, the opposition of local communities to operation by Glencore. Communities don't often have standing before ISDS tribunals. Then I suppose states are tasked with the difficult task of representing the state's own defenses, as well as potentially protecting community interests, which can be difficult at times. But maybe we can revisit that in the Q&A a little.
But here, I understand what the point you are making, but I think here this very straightforward point for the state, which is these are judicial decisions, and what can we say that that's an arbitrary step on the part of a government, or can we, or has there been a process in which the other party has participated? So I think that these are different issues from just communities' intervention or not.
Thank you. Mr. Burley would probably continue the discussion and share with us a view from inside the mining industry.
So I'm likely to be the controversial one. So there's two things I've learned in 20 years of working in emerging markets. It's two words I've learned in 20 years, and it's stakeholder balance. If you get it wrong from day one, you're going to be fighting for 10, 20 years. And it's down to the owner, the miner, the oil and gas company, equally the government, to understand what they're signing up for. Because it's no good crying in your beer 10 years later saying you didn't understand from day one what you was getting into. And unfortunately, the more time I spend looking at mining disputes, the more stakeholder balance at the beginning is ignored, because people simply ignore what they are signing up to. And 10 years down the line, 20 years down the line, you get disputes. And those disputes cost lots of money, and they involve lots of lawyers, which is good for you guys. Yeah, but it's generally not good for the state, and it's certainly not good for a government, because developing countries have limited budgets. Miners don't have limited budgets. Miners can spend hundreds and hundreds and hundreds of millions a year on defending a position. And unfortunately, states then find they're in a position where they have to either agree or take a position that potentially is not what they want to, the position they don't want to be in. And I've seen it so many times in the last 5 years. feasibility studies, pre-feasibility studies, bankability studies is the time to get it right. It's the time for everyone that's associated with a particular mining project to get it right. Because if you don't, I can guarantee you're going to have a dispute in 10, 20 years' time. And that can be an environmental dispute, that can be a social dispute, that can be a governance dispute. Miners are getting very good at particular parts of ESG. Unfortunately, we've had a particular case where environmentally they haven't in Colombia, but I've seen over the years they've become far more sophisticated. They're far more sophisticated in terms of social involvement in countries and how they develop aspects around a mine. They're getting better. What they're not so good at is governance. And that's where governments, unfortunately, from day one, need to be smart. And unfortunately, I've seen over the last 5 years with some of the matters that I've worked with, governments are not so smart. You know, they have a limited budget, so they put people into situations that they shouldn't be in. It's very difficult to have a dispute with, you know, a David and Goliath sort of situation. And a miner will always be the big guy. Sovereign governments in developing countries are always going to come off second best. That's where the change needs to be at the moment. And this is where governments and people that work for governments in terms of investment agreements, in terms of their lawyers, in terms of people that advise them, they need to be smarter because mining is not going to go away. It's a necessity. You know, copper, especially at the present time, lithium, you know, everyone thinks there's an evolution in terms of electric vehicles, and critical minerals is focused on electric vehicles. Wake up, guys, it's not. It's defense. You know, for the last 10 years, the Chinese have been stockpiling critical minerals from around the world. And in the last 2 or 3 years, the US has woken up and said, shit, Chinese control the world in terms of critical minerals. If there was a war in the next 5 years, the Chinese are in a great position. The rest of the world, not so. Yeah. So the message and what's happening in the mining sector, you know, not many people truly understand how that's going to evolve. And for countries that do have stockpiles of critical minerals, battery minerals, you know, some of the bigger minerals, especially copper at the moment, they've got to be smarter or else they're going to come unstuck in disputes. And, you know, it's not fair. Stakeholder balance at the beginning, if you get it right, will run through a life of a mine, run through the life of a project. If you get it wrong, I've seen it too many times, you're going to have fight after fight after fight, dispute after dispute. No one wins other than the lawyers, which is good news for you guys. Honestly, my advice to any sovereign government at the moment is there's a wake-up call. Don't pick a fight with a miner, especially the top 10, because they've got unlimited access to some of the best legal guys in the world. I've seen it just recently, you know, with disputes, class actions I've been part of. Early days, as the industry evolves over the next 10, 20 years, get that balance right at the beginning. And if any of you are advising your clients in terms of, especially governments, it would be employ the best people you can now, because it will save you 10, 20, hundreds of millions later. Sorry to be the broker of sort of bad news, but that's the reality, guys. I'll leave it to you. I'll take some questions after. I can take some questions.
Perfect. Okay. Thank you. Since you've opened up the questions, I'll come back with some later perhaps. But Juan Carlos?
Well, I'll respond to that. And I'll take another controversial position, which is that I'm going to sympathize with Richard in the sense that mining companies have a difficult life, and bringing into being a mining project is a very difficult thing, and unfortunately you wouldn't know it from most of the ISDS cases which are driving this problem, the reputable companies that Richard mentions, which apparently include Glencore, but there was, let that pass. Those reputable companies who already have a difficult life will have their life made even more difficult by the fact that ISDS, which is the process that most of them choose to resolve their disputes with the government stakeholders, which are invariably a very important component of the success of any project. ISDS is a system that's mired in profound disrepute, and mining disputes have contributed in no small way to this disrepute. But unfortunately, for reputable mining companies such as they are, it is not they who are driving this process, with some exceptions such as Barrick Gold or even Glencore. Most of the really major disputes and awards that have brought the system into disrepute have been brought by fly-by-night companies who have taken advantage of the many weaknesses of the ISDS system to bring claims that are totally surreal, lacking any anchoring in reality, and playing on the total ignorance of arbitral panels in order to secure huge awards, which naturally have driven states, including former strong proponents of ISDS, such as the EU and Spain and Great Britain, to doubt the wisdom of remaining in the system. And in this context, the award that is worth reflecting upon is Crystalix. Crystalix is an award that you will see cited in every single mining case, standing for the proposition that once you have proven the fact that damage has been caused by governmental action, you don't need equal certainty to prove the quantum of the damage. And so therefore, very speculative DCF exercises are admitted, because once you've got over the threshold, over the fact that there was damage caused by the government, then you're in the clear to say whatever in terms of quantum. And the odd thing about Crystalix is that its fact pattern doesn't even support that finding, because the weird thing about Crystalix is that it involves a mine that has never really come into being in Venezuela. It's supposedly a very large deposit which has been under concession, license, and whatever since the 1960s. And from the 1960s to today, not a single ounce of commercial gold has been produced in that deposit, or another deposit that lies very close nearby called Las Brisas. The Crystalix one is called Las Cristinas. What they do, or what they have produced, is 5 investment arbitrations, probably 6, because the gold reserve now has resumed. Total amount of damages claimed as foregone profits in all 6 must be getting on to $20 billion. And it has always been argued that actually these profits would have been realized had the Venezuelan government not done whatever it was that it did. And to be fair, and Richard will be sympathetic with this, the behavior of the Venezuelan government in connection with all of these matters has been far from exemplary, but not to the tune of $20 billion. Crystalex got an award, which it is now the mining company itself went back. The Crystalex case was advanced by essentially a litigation funder. So that's the other thing that Crystalex brought into the picture. Litigation funders who, ever since they have become involved in a major way, the claims relating in particular to mining, but also to hydrocarbons have been getting more and more and more surreal, which is a paradoxical outcome, because you would think that litigation funders look at cases with a very, very critical eye, because the rationale is, well, of course, litigation funders make money by winning cases. So why would they take on foolish or surreal cases? The thing is that litigation funding doesn't work exactly like that. And to make money in litigation funding, you don't need to win cases. It's better if you don't lose them, but you can make money without winning them. And in fact, that's how most of the money is made, in ways that at the moment are not germane. So what is important is that the greater the claims, the better it is for the litigation funders in terms of selling pieces of the litigation to investors who need to include certain types of risks in their portfolio, put it that way. Crystalex brought into being these two things. And the fact of the matter is that if you look at Crystalex at this point has proven that it's absolutely not, it's not even that the certainty of damage that the Venezuelan government did something or the other is completely goes counter to the fact that even to this day, not a single ounce of commercial gold has been produced and will continue not to be produced, because producing gold in that particular location is not easy. Same as producing copper in Balochistan, which a tribunal who has a very, very dubious understanding of how you bring a mega project into being, decided that actually the fact that there was a lot of copper in a certain place in Balochistan of itself was proof that this project would happen, when in actual fact, the amount of mineral that's in the ground or wherever at some point is a useful thing to know, but in no way determines whether you can have a commercial project or not. Or in the case of the Balochistan copper mine, which to this day hasn't happened, although they're still trying, you need two giant projects. On the one hand, the mine itself, and on the other hand, a water pipeline that will take copper concentrate slurry to the coast in Pakistan. This water pipeline needs to be filled with water in a place that truly is a desert, even more so than Cerrejón, and needs to exploit an aquifer that's shared between Pakistan and Afghanistan, over which no international agreement exists. So all of this, this is a fantasy project. And a tribunal saw it fit to say, yeah, an investor, if you presented this project to him, an investor would pay for this project today $6 billion. This is, beyond wrong. It's not even understanding what's at issue here. So the problem that reputable companies have is that this particular dispute resolution method is becoming more and more difficult to use because the states simply won't play ball. So you can, even if you can have a not so bad stakeholder dispute, which in the past this would have made perfect sense to solve it through ISDS, increasingly no longer, because all the disputes are just surreal. And so the life of miners is getting more complicated at a time when really it would be good if it were becoming less complicated, because all of these minerals are very necessary to our lives, and we kind of like don't know it, but it's like the people don't like to think about these things, but it's like a sausage factory. If you like sausages, don't go to the factory where they make them, because you'll be forever put off them. Well, if you have an iPhone, the best thing you can do is not think about the substances that go into making it, because when you start thinking about it, then you realize that on the one hand, you need the mining companies badly, and on the other hand, that getting all of these minerals is not simple, and not. Mining is a dirty business in a physical sense, quite apart from the involvement of gangsters
and corruption.
Yeah.
Thank you, Juan Carlos. I have a general comment, and perhaps that may evoke some responses from all the panelists, really. But it's in the nature of a mining dispute that it is capital, not just that it's capital intensive, but it is capital intensive upfront, leaving potentially a mining industry, a miner in a situation where they have already exposed themselves to a significant degree of risk, and then are facing regulatory, environmental, or challenges from the community. And then from the state's perspective, they may claim in an arbitration that we have a legitimate expectation to exploit. From a community point of view, a miner may say, well, the state should be the one protecting it. Or in an SDS claim, they may say, well, we want our sunk costs back. So is there anything, do you think that this feature of the mining industry makes it special or unique to ISDS or these sorts of proceedings?
I mean, to be honest,
I want to think from the perspective of the law. I don't see any difference in one particular type of investment and another. You obviously are always risking. You're obviously interested in making an investment profitable, and to have the guarantees to do that without an intervention that is arbitrary. And I think that is common to any kind of investment. So I wouldn't really say that mining is a particularly different type of scenario. See, what is happening though with mining is that, and the majority of cases that the examples, if you want, that come across, is really about sometimes lack of compliance with environmental regulations in a country. So if we think about mining, not only I mean, there has been some comments on minerals that are fundamental for a transition to currently speaking, but there are other, let's say, type of mining like gold mining, which it really poses questions around the system itself. I don't know how many of you are familiar with tailings and the regulation of tailings. Now, this is interesting because tailings do not require insurance. Now, this is huge because if a tailing really goes wrong, and it does affect not just the communities, but natural capital, etc., etc. there's simply no way that the state is going to recover anything from it because a company is internationally speaking cannot get insurance for it. So it's a huge risk that is being taken. It's been taken not by the company, it's been taken by the state and by the communities that may have to face that if it goes wrong. So, you know, it's just some of the issues that surrounds a certain type of industries, oil and gas, I mean, exploitation, let's say at sea, equally, there is no insurance at place in platforms when it comes to exploitation of oil at sea. So, you know, there are certain, I think, challenges to the law, because if it goes wrong, there is no way that you can recover damages for that if you are on the side of the communities or if you are on the side of the state.
Any other comments?
Well, you can. You can recover damages for that. Like, you know, if you're BP and you spill oil in the Gulf, the US government says, well, guess what, BP? You know, the Obama government at the time said, well, you need to put this huge amount of money into this bank account tomorrow, or you will face the consequences. And they did. Now, if any other government had done that, then they would have faced an immediate ISDS claim. And that is the problem with the ISDS system, that it was always designed so that only certain people ended up in court. The British, the Spanish, the EU, the Germans were very happy with the system for as long as they weren't on the dock. And once they began to be put on the dock, they very quickly got less and less enthused, which I celebrate because it was always a very unfair system, and it was always just a matter of time before it became evident that any state is potentially vulnerable to be shaken down by investors advancing completely surrealistic claims. So the fact that there are less and less state proponents for this system is better. But you know, Monica's point is valid in the sense that you know, there's things that as a government, when stuff happens as a government, you should be able to do, such as the US administration did when the Macondo oil spill happened. Most governments would have had those avenues close to them, or had they done them, they would have had to face gigantic ISDS claims, and surely that's not how the system was supposed to work by the people who designed it.
Okay.
Yes, thank you very much, Artet. I believe that, as previously mentioned, mining is a highly regulated sector, and therefore I'm thinking just lastly, comparing to other investment, maybe in a mining investment, investors should conduct a more rigorous even due diligence, because taking into account the big impact that a mining project have in a social and environmental in a country. That's the reason why it is fundamental to have the environmental impact assessment, the social license to operate that recent awards are referring to. And well, I believe that it is important also to take into account the rights of the states and the sovereign power for mineral resources. And that's the reason why for conducting a mineral and a mining project, a lot of licenses are required. And that's the reason why, depending on the country, you cannot put a mining a plan to operate in 1 year. That's the reason why a lot of requirements have to be complied before that investment could be made. And that's the reason for this is that as I mentioned before, a lot of social and environmental impacts are at stake.
Thank you. Yeah. So shareholders, analysts, I've got my sort of head in my hands 9 out of 10 times when I hear analysts on investor calls trying to hold miners accountable. They simply do not understand what they're investing in a lot of the time. You know, when I was running projects around the world, you know, I'm getting old now, unfortunately, but there's younger people in the room. And my best piece of advice to them always was when they got off the plane, look at your feet. And we could be in some crazy country around the world. And I say, look at your feet. And it could be an Australian, a guy from the US or Canada. And they go, what are you talking about, Richard? I said, look at your feet. That's why. I said, whatever you think you know, forget it. Because everyone has a preconception of what it's going to be like working in some of these places. And I can assure you, whatever you think you know, forget it. Yeah? And that's the trouble with investors, analysts. They've never done it. So they don't know what to expect. So the questions they ask, some of them I think are best, dumb, I could go further. So, you know, when I hear some of these things, a lot of these guys are going to wake up. Same with governments. You know, it's about being smart. And unfortunately, you know, smartness is a commodity, and it's a rare commodity I found in 20 years around the world. Governments especially have got to get smarter so they don't find themselves in these types of disputes. Yeah? And if that means going out to big law companies or people that they think they can rely on to support them, do it. Because it's far cheaper to do that at the front end than 5 or 10 years later when you're fighting a miner in a court. Because that's when it gets expensive. And unfortunately, like you say, the younger guys of the industry, they don't want to do these crazy places. They're happy in the US, or they're happy in Canada, or they're happy in Brisbane or Perth, or London. That's not where the action is. And that's not where you're going to sort of add value to a project. You've got to be on the ground, and that's how you protect the interests. And that's where that stakeholder balance goes.
But we're both British, you and I. And I think we would agree that not even the British government operates according to these principles. So let alone, you know, because again, governments always have like budgets and so on, even here. So forget about the government of Guinea, who on top of everything else will likely have all kinds of problematic incentives at play. So, you know, I wish it were possible for governments to be intelligent, but you know, as I get older, I find that it's getting harder and harder to believe. But so you have to, you know, kind of think that the other party has to contribute something by, you know, being slightly more scrupulous.
Well, that's where ESG comes in. And as I said, the E and the S, a lot of miners are getting good at. It's the G they're not so good at. And that's where the grey areas come into play. And that's where the grey area that the government in that particular country is going to become affected. And it's, say, the British government, I wouldn't say are particularly smart in understanding critical minerals if you've read their last defence paper. All they're interested in is critical minerals that basically can build drones with. Yeah? And all they talk about is supply chain. Well, actually, it's easy to say, what is the supply chain? You've got to go into countries and understand them parts. You know, you've got to go into them countries and understand what that mineral looks like, how you're going to achieve it. Because there's 20 guys in front of you, including the Chinese. You know, we are in a bad place at the moment. A lot of people don't realise how bad a place we are in as the Western world, as the EU. The US woke up probably about 4 years ago, and the lights just come on. They all of a sudden went, we can't build nothing without this stuff. You know, and they looked around the map, and the Chinese are everywhere. So the Chinese are good at managing developing economies. They work in a different way to we. We've got different principles. So we're playing catch up. And it's a really difficult game to play in terms of minerals. Because like we've said, it's a from pre-feasibility to commission mine, you could be talking 10 years and $3, $4, $5, $6 billion.
Thanks. Maybe we open the floor up to questions.
So one microphone, Web 3, right? Yeah, thank you very much. Very interesting presentations. And also our online participants, you will be able to ask questions either by using your voice or just by typing the question, and we'll be able to read them. It's interesting that oil mining and gas sector also accounts for the largest share of ISDS disputes generally. In a way, it makes sense because these are very large disputes, and states need these investments, and then they may have problems. Also, this sector is the largest when it comes to the share of allegations of corruption. I did a study for the UN Office on Drugs and Crime on corruption and investor-state dispute settlement, and mining, oil and gas were at the top. So my first question is, why do you think that's the case? Why it disproportionately involves corruption? And the second question is, we discussed the urgency of having more mineral and those minerals which are not available perhaps in Europe, and the problems with regulatory problems, the slow pace of approval processes and so on. So what can states do in order to facilitate it without compromising much on ESG, on those three considerations? I don't know who would like to, probably Richard, you raised the geopolitical issue first, so you can talk about it perhaps.
So yeah, so the D word, it's everywhere, unfortunately, but depending on who you represent, government you represent, company you represent, you have to manage that, because as we go into emerging markets or developing countries, the values we have can differ to theirs, and it's how you bring those values together. We've got a bribery act in this country that exposes everyone that works abroad to potential prison. So you've got to be really clear in your own mind as an operator or someone that works in these countries, how you operate there. And there's a line, I always just call it the line in the sand. You can go right up to it, but you can't step over it, because if you do, you put yourself, your company and your country in a position whereby you could be on the news tomorrow. You don't want to be on the news. You don't want to be in a foreign prison. So it is difficult in some of the Asian countries. It is difficult in some of the African countries, South America. But I think as the mining industry and the oil and gas industry does develop, the expectations of countries that we represent, EU, UK, US, Canada, it could be anyone. When we go into these countries, we have to set a bar from day one, and we have to set expectations from day one, because if we don't, I can assure you, corruption will come looking for you, and it doesn't stop. If you're a mine and you put an investment into a country in terms of a pre-feasibility study, a drilling program, you could have spent 10, 20, 30, $40 million. Before you know it, the state's going to come looking for you, and it's going to be a conversation you can't have. So what do you do then? So it's about being eyes wide open. And unfortunately, I would say a lot of companies don't go in eyes wide open, they go in eyes wide shut. And that's where, again, they need good legal advice or good people that operate in these types of countries.
And just to give an answer to your question, why are these sectors where all the corruption is? Well, because that's where the money is. As simple as that.
True.
Yes,
Thank you very much.
Sorry. I think corruption is just started to be quite center stage. Generally, when we look at consequences, post Nigeria and PNID, where, I mean, it's interesting, a panel of very experienced arbitrators that actually didn't see it. And I think that in countries where division of powers and control may not be that strong, I think this, because you ask, why do you think corruption may happen in certain jurisdictions? I mean, not all jurisdictions have a very strong rule of law. And I would say that partially these type of situations may arise in contexts where you don't have that scrutiny that is actually quite strict and working. So, but I mean, on the second question about the urgency and whether there is a way to speed up, I mean, what is that urgency? Are we talking about, I don't know, a way of financing and making real a kind of tech evolution right now? You know, the technology is really requiring minerals, rare minerals. Countries want to run, for example, to do deep sea mining right now. I mean, let's put that example, such deep sea mining, and from one perspective, you could say, yeah, let's try to do that as soon as possible. I mean, some companies are really trying to speed up the process. But I think when it comes to environmental consequences that may be irreversible, like in the case of deep sea mining and the context of climate change, I don't know, I would be cautious about that and care really about having rules that are clear for everybody to be able to know exactly what the law is requiring. And only in that context, I think that the possibility of any dispute that may come later can be manageable. Otherwise, with the objective to actually achieve, you know, certain, I don't know, evolution and aims, you may actually be fostering a very, very difficult situation later. And that's what we are inheriting right now. I mean, the whole climate crisis comes from that kind of approach, you know, to just get things done without thinking necessarily what the consequences may be.
Thank you. If I made a brief note regarding corruption, as I mentioned before, it is important for investors when they are going to invest in the country to supervise that the process is well done and in compliance with host state laws, and act and adopt, investors should adopt measures in order to prevent those type of corruptions, because if not, investor should know that if corruption arises, their investment is not protected. So this is what I wanted to point.
Thanks. Go ahead. Yes.
Thank you. I have a question for Richard. You remembered me of a tip my father would give me before an exam, which was basically don't make any mistakes. Since you mentioned yourself, it's about being smart. Could you maybe elaborate what being smart means? Because you mentioned yourself that everybody's got their own perception. So everybody would probably agree with you that being smart is what it's all about, but everybody has a different understanding of what being smart actually means. So with your experience, what does being smart mean?
It's a good question, actually. Yeah. So let's assume that you're going into a new country, a country you've not worked in, or you're very, very unfamiliar with. You know, it's understand the people you're dealing with. Culture is everything. If you don't understand the cultures that you're working with, you'll fail. Yeah, and every culture is different. And just because you assume you come from a superior culture, don't for one moment think it's superior. Learn what people are telling you. Understand what people in specific countries, what's important to them. You know, we spoke about some environmental aspects tonight. You know, in countries I've worked in, you know, water is critical for different people, herders. And when you get into a country where you've got herders, they've been there for hundreds and hundreds and hundreds and hundreds of years. So they're important. So culturally, what makes them important? Go and find out. Go and talk to them. Get off your ass. Don't sit in your sunny office, in your ivory tower. Go get on the plane. Put yourself in a desert for a few days. Go and ask these people, what's important to you guys? No, well, all the guys. Okay. So we, on this particular project, can recycle 80% of the water we use. And tell them what you're doing so they understand that. Because being smart and engaging with people at grassroots level, I can tell you that will save you dispute after dispute after dispute in years to come. What people do that sit in executive positions, they don't do that. They assume that it will be okay. Well, don't assume that, because it won't be okay. Small people matter, especially in countries like we've spoken of. So engage with them, and don't send people to engage with them. Do it yourself. That's the smart thing to do.
Thank you.
Yeah. Okay, introduce yourself. Yeah.
My name is Pietro Bombonato. I'm a lawyer with Trinity International LLP. I have two very quick questions, if I may. The first one is to Mr. Boué. I completely agree with your assessment of the Titian and Pakistan award. And I just wanted to ask you if you would agree that the biggest issue there is the 6 billion, so the valuation. And why is it, in your opinion, if so, it's so difficult to move over DCF in those kind of disputes? And actually in Titian, the tribunal tried to move over from DCF. They used modern DCF, which led to an even higher valuation of the claim. So in your view, was that good? Or if it wasn't, what would have been a better method to evaluate the claim? And then if I can, a quick question to Mr. Bowley. My wife being Australian, I spot a familiar accent. And I think Australia is one of those countries that have defeated a mining magnate with unlimited budget in Clive Palmer recently. And I wonder whether there are any lessons that can be learned there from other countries.
Well, first, Clive Palmer, I mean, they've defeated him in the first round, but that'll run and run. And, the good thing is both of them have unlimited budgets. So we'll be around to, it'll be lots of fun, but it underscores the problems with ISDS that Clive Palmer is, who everybody knows as one of the foremost Australian miners, is suing somehow as a non-Australian. So that goes to show what the issue with the treaty system is. In terms of Tethyan, obviously the valuation absolutely is the biggest problem with it. It's not that the tribunal wanted to move beyond DCF. I mean, Tethyan is such a horrendous decision because for a variety of reasons, but one of them is that they say, well, valuation methods evolve, and so awards should evolve to, well, whatever. But that's not the exercise that the tribunal is meant to be undertaking. The tribunal is meant to be figuring out how two hypothetical parties would have gone about transacting on this particular asset on a particular date. It's not the idea to find novel ways of determining value. Two hypothetical businesses, how would they have transacted on that day? And no transaction that I've ever seen, and I've seen many, has ever been done on a so-called modern DCF basis. Choosing the modern DCF was particularly silly because it's quite evident that at least 2/3 of the tribunal members didn't have a clue what this whole thing was about. And you can tell because one of them was also in the PNID decision and wrote it. And from that particular award, you can tell, for example, the award mentioned that, well, oil prices move up and down, so that takes care of that risk. So we can discount it. I paraphrase loosely, but the fact that oil prices move up and down is the risk. is so it's not that what takes care of the risk. So again, this was somebody who turned up to a black tie dinner dressed up as a chicken and cannot even understand what he did wrong. That's how bad this is. So, you know, moving away from the DCF from time to time, you know, should not be in the direction of more and more speculative stuff. The DCF is speculative enough, which is why it continues to be the preferred method, because particularly for unbuilt projects, if you build a DCF model with speculative enough assumptions, the sky's the limit in terms of damages. So you get things like, for instance, to retake Monica's comment on deep sea mining, you take Odyssey Marine in Mexico, an offshore mining project, which intended to mine a deposit the likes of which has never been mined before, with technology that has never been used before, that doesn't even exist as of today. And the claimants' lawyers have no problem in standing before a tribunal and saying, on the valuation day, an informed and uncoerced investor would have paid for this project hundreds of millions of dollars. And that simply is a complete and utter lie. And they know it. And they're merely relying on the fact that the tribunal is likely ignorant and can never be trained to discern complex facts about a complex industry, or there's even more problematic issues at play, such as were in evidence in Tethyan, where one of the arbitrators had relationships with the consultants who happened to advance this new valuation method. So that made the selection of the so-called modern DCF even more outrageous.
Thank you.
Question was about Australia, yes? So Australia is going through a change. And it's not a good change for them, unfortunately, because most of their industry is based upon iron ore. And the Pilbara blend, if you've heard of it, is the Pilbara blend. It's what makes the blend for iron ore special. And Australia have had it for years. But that blend, unfortunately, is becoming more and more difficult to mine, which makes production costs higher, which makes, obviously, the product more expensive. And of course, our good friends, the Chinese, have been in Africa for years, and you may have heard of a project called Simandou, and they love that place because the blend in that place is going to be so special that Australia in the next 5 years is really going to find it difficult to compete on the iron ore markets. So Australia is going to go through a change, and it's going to be quite a hard change. You know, the Chinese are smart. They're really smart people. And technology-wise, don't think that they're yesterday's players. They're as good as the rest of the world now. So, and going back to your answer around arbitrators, let me be clear with regulators. I've worked with regulators over the last number of years, and they're some of the smartest lawyers I've ever worked with. But when it comes down to understanding a technical dispute between a miner, they struggle. And this is where a lot of miners do play their cards quite well, because they confuse lawyers, they confuse regulators, and it is a very, very difficult sphere for lawyers to work in, because some of this stuff is immensely technical, and unless you understand it and the processes, capital investment needed, the risks, I can tell you, I've seen some of the best people in the SEC sit there shell-shocked, you know. So it's a difficult one for you guys.
Perhaps if there's one more question, if time, I think if there's one more question we can take, otherwise, perfect. Any last comments?
Sure, perhaps one last comment on third-party funding. I would actually say that as well as there may have been, I mean, there was a negative view before on the role, but I would also suggest that the other way around is been real at the same time, because some of the disputes concerning mining are so ambitious that some states may require also funding, and third-party funders are doing it. So it's not just one way, and also the consequences. I mean, legal systems are developing, and it's not just arbitration. It's happening with communities actually accessing courts in the places where those companies are incorporated. And third-party funders make it possible. I mean, we have seen in the oil and gas industry in this country that becoming reality, with Shell being sued in the UK, and other cases in mining disputes in English courts. And some of them have been possible because of third-party funders, and some of the biggest group litigation cases in this country concerning huge projects abroad are happening because of third-party funders. So I think it's something to watch, and I think it will possibly continue to the extent that the law allows.
Any last comments? Perfect. Thank you, Monica. Please, please join me in thanking the panelists for a wonderful panel.